Apologies, Anupam. Just wait for the recording to start. Okay,
Okay,
recording has started. We can.
okay, okay. Good evening, everyone. As Sandeep sir has already told, I remind you again to please mute yourself, turn on your videos, and also please ensure that you are not sharing the screen. So, all right, today we are gathered here for the third lecture of the Career Orientation Lecture Series conducted as part of the Project Complete Lawyering presented by Cochin Institute of International Arbitration and Law and Justice Research Foundation powered by LJRF Voice. Today we have with us Honorable Judge of High Court of Kerala, Justice A. Muhammad Mushtaq, to talk to us on the topic future of legal profession, prospects and challenges. So in order to begin the session with the welcome speech, I would like to invite Nandita Karunakaran, fourth year student of BBA LLB at Christ University, Bangalore. Please welcome Nandita.
Nandita, 1 minute. Let me see whether.
I think there is need not to any formality. We can proceed with the session.
Sure. Due to the
I'll
paucity of
introduce
time.
myself. I'm
Yes,
Justice
sir. Yes.
Mohammed Mushtaq, Judge of
Yeah.
Kerala High Court since 2014, January. I was a lawyer before practicing High Court from since 1996. I passed 5 years batch in '89, and I always take pride myself. I am the first to be enrolled in Kerala as a 5 years batch student. Uh, I enrolled in the month of October 1st in 1989, passed out year somewhat and in same year. I joined the law college in Udupi, BBCL 84, 89 batch, first batch of 5 years course. Then I practice in Kannur, where is my hometown. Right now I'm in my hometown. Where I practice in municipal court and district court for 7 years. That gave a lot of exposure to understand the nitty-gritty of litigation practice. I've attended almost all the courts, including consumer court, Tahsildar, accommodation controllers, all the kind of the hierarchy which you find in the statutory bodies. That was quite good experience, I believe. I was a very modest lawyer and practicing because I was a named lawyer, a young lawyer. You are stepping into a world where there will be every lawyer will be declared as themselves as a real 14. No, would be the affair you find when you step into the bar. That's what late Justice Khanna said in his Joseph Throne, I think. When he stepped into the Chandigarh bar, no, he found a lot of pompous head sitting and proclaiming themselves. The same feature you will find when you enter the bar room. Everybody will proclaim like a Louis XIV, and you will be very diffident, perhaps. Of course, it is good to know the people, but never get down and bogged down by such attitude of the people. Always keep in your mind there will be a day where I can show yourself. So that was my practice for 7 years. Then I did LLM in labor law from NG University. I also did my master's in space and telecommunications from Paris 11. There is a program of a university completely funded by French government. Of course, one need to know primary level of French language. But I of course, I had a certificate course from Alliance Francaise from Netherlands. My French was very poor, but still my director allowed me to join for the reason that he was looking someone from India at that time. To be admitted in this program. So that was a wonderful program for me because it is really an academic program focusing on practical side of the telecommunication and space work. Then I did attend the Hague Academy on Private International Law. And of course, I had a couple of publications, international publications, astronomical Congress. It's the World Body of Astronomy where they also deliberate on space law. I was really interested in satellite navigation and making its regulatory laws. My whole presentation was on that, GPS related issues, when navigation is used for air traffic management, how the legal issues likely to rise and what kind of regime we should. Those area was wonderful for me because nobody has credit to that path before. I think 3 publications have in that Astronomical Congress. Then I became a judge, then I altogether a different terrain. But I tell you one thing, once one of the professors in McGill in Canada told me, it's not what you learn, never mind, whatever you learn in your life, maybe some point of time, you get to know what is your learn, whatever the kind of field you choose. That is really remarkable comments made by him. I always feel kind of exposure I had in the studies always led to me a different angle, kind of thought process. Even though space law has no application in my day-to-day life, but it has opened a different dimension. So, of course, I did mediation training in 2005, and again, Supreme Court committee also trained me when as a part of court and expedition. So that is all about me. Of course, I want to know about each of you because there are 20, how many? 25? Anyway, we'll be asking. I think it will be more interactive rather than a monotonous lecture. You will be bored about the monotonous. And I'm quite happy seeing a lot of girl students around. Of course, you are the future of the legal profession. And the days are not far, the men will claim a reservation in the legal profession, especially in the judiciary. And you're going to outnumber them. So thank you all for choosing this program and the wonderful initiative from Thomas and his team. Because you really require proper guidelines, mentoring. This is a life where you have a good opportunity and great opportunity. How you use this opportunity matters in your life. These are the words. We can go to straight to session, Thomas. Sandeep?
Yes, sir. Yes, we can
Yes,
start.
sir.
We can start. Yes.
So I have a small slide here. I'll share you. I just want you to have a look at the slides. Right. I'll just see that. Are you able to see this?
Yes, sir. Yes.
Yes, sir.
Yes,
Yes.
sir.
Yes.
Daughter here, who is a successful lawyer. I just categorize large files, money, less files, huge money, files, equal money, files, no money, no file, no money, none of the above. And I would like to ask each one of you answers on each line. What is your response on this? Whether you claim the large files and money and large money, or less files and huge money, or files or equal money, files, no money, or no file, no money. That will be the situation when you will end up, or none of the above. Let me know each of your response on this. Yes. Anupama, you are the starts with the alphabet. You just tell me what is your response.
Files with equal money, sir.
Okay. In which year now, Anupama?
I'm a final year student, sir.
Where you are studying?
I'm studying in Government Law College, Calicut.
Calicut. Okay. So, according to you, the files with huge money,
With equal money,
equal money. Okay. And Revati, I just I don't know your actual name is this. I just see from your screen and I call your name. Revati, what is your response? Revati, you are muted.
Sir?
You're not audible. You have seen the screen as
Yes,
shared by
sir. Yes,
mine?
sir. Yes, sir. The voice is little lower, sir, so I couldn't hear properly.
I just want to know what is your response.
Sir, I think none of, sir, I think none of the above, sir. I don't think that a successful lawyer will be equated with files and money, sir. So I don't think any of them will be a
What is your answer then?
none of the above, sir.
None of them. But then what is none of the above? Yeah, of course. Then you must have something in your mind. How do you define
Yes,
it?
sir. Actually, it should be like who is more useful to the client and the society, and for himself will be a good lawyer, sir.
Okay, that is your response. So who will be useful for the money? So you're going to do a lot of pro bono service?
Not only pro
You
bono,
like to
sir.
be you want to be like a Gandhi?
No, sir, no. I'm not saying that pro bono works and legal service is the best one, but only money and files will not be success in my terms, sir.
What is the reason for you? What is the reason for joining LL? What is the reason for joining law? No, you want a career in law?
Yes, sir, surely. Career in law only, sir.
What is the aim you have?
Of course, we should have files, cases, monies, but only that is not success.
Okay.
I think I will need a more impact in the legal field, sir. I have to make some impact by myself.
Okay, right. You call it impact. Yes, I know that. Impact. We know what is your response?
Equal file with equal money, sir.
Okay, equal files, equal money, like you follow the Anupam Aisha, right? Yeah. Okay.
Yeah, sir.
Out. Rahul?
So my answer would be less files, more money.
Oh, less files, more money. Right. Good. Okay. Anandu?
So my answer is first one, sir. Lots of file with money.
Lots of fun, not money. Okay.
With money.
Okay. Kavita?
Sir, I will opt for third one.
I mean, like equal money, equal file. The third one?
Yes, sir.
And Ashok?
Sir, my opinion is less file with huge money.
Okay, that's fine. Nandita, you're also law student, right?
So then, yes, sir. So same, sir. Less files, more money. It's a little selfish, but yes.
Yes. Abhiram?
Sir, myself, successful lawyer is, before moving to that, sir, what is success? It depends upon the person, sir.
That's what we asking. Yeah. Tell me.
Sir?
No, you can answer.
Sir, myself, the beginning, no file, no money, and then going to next level, upgrading, sir.
Okay. Next level. Safila? Safila, you're not audible. I think none of the we'll follow the Revati. What is the reason for that?
Because we need money, also we need files. But in spite of it, if a file with enough money, only we can succeed as a successful lawyer. Without money, with a huge age, we can be a successful lawyer. In every field, we need to.
Okay.
I think she is breaking up. Unfortunately, she's.
Her voice is okay. Cincy.
Sir, I feel it's none of the above. Why? Because we know there should be files and there should be money. But what kinds of files we are dealing with, that makes a difference. and what we are getting from doing a case in academically, we have to improve ourselves every day. നമ്മൾ കാണുന്ന ഓരോ ഷാലി മൂവ് ഓൺ ടു മലയാളം.
Absolutely, no problem.
സർ നമ്മൾ ഓരോ തവണ ഡീൽ ചെയ്യുന്ന ഇഷ്യൂസിലും ഒരു ഡിഫറൻസ് ഉണ്ടെങ്കിലാണ് നമുക്ക് പല ഏരിയാസ് കവർ ചെയ്യാൻ പറ്റുള്ളൂ. അങ്ങനെ കവർ ചെയ്യുമ്പോഴാണ് ഇൻ ഫ്യൂച്ചർ നമുക്ക് ഏത് പൊസിഷനിലാണ് ഇരിക്കണമെന്നുണ്ടെങ്കിലും അതിനകത്തൊരു എൻലൈറ്റ്മെന്റ് നമ്മുടേതായിട്ട് കൊണ്ടുവരാൻ പറ്റുള്ളൂ. ലോയിസ് എപ്പോഴും ഡൈനാമിക് ആണ്. ലോയിസ് ഡൈനാമിക്. ദാറ്റ്സ് വൈ ഐ എം സെയിങ് സോ. വി നീഡ് money, but at the same time there should be different kinds of files we are getting.
So it should not be monotonous work like your particular. Yes. You always need a challenging files and do differently every day. That's what you mean. Yes. Renju?
So less files with more money, sir.
Oh, great. Akshay, Raj?
Less files with huge money, sir.
Oh, great. Okay. Anisa, the last one, right?
Less files with more money, sir.
Okay. So, okay. So you are all, you should give a big answer to Revati. The answer is the right answer in this. Why I tell you the reasons. Can you see the screen?
Yes, sir.
I've referred as herd mentality. Now you are still all your stereotype. You just see what you perceive, what you're seeing, and you try to make within you. To build a practice in a litigation or whichever on what you have perceived. The perception is based on what you have seen. That's called herd mentality. That means that you look around and you see a lot of practitioners making money, a lot of practice, then you follow the same thing. That's where the Revati had a difference in opinion. Perhaps today's subject is all about that. Revati's mindset, how to create an impact in yourself in a different way. History tells about such people who've been rated as a successful, whether it be Gandhiji or Sri Narayana Guru, who understood a society in a different way, and people rated them, they are the successful people. Why? That's the subject today. I stop the screen sharing and I'll tell you a bit more about this subject. Revati got his point near to that what I am intending to say. Why Sridhara Guru hails as a hero? He could have Sridhara Guru merely challenge the caste system to the society and follow what everyone do that time. He never challenged the caste system, but he taught in higher principles. Or Jadi, or Mother, or Deva. Putting things in a different way that people understood. That will eliminate all caste system. Instead of directly challenging the same, we put in a different way. People hate Sridhara Guru for that too. Why Gandhiji is being hailed? Because of different thought process. He was resisting oppression by British, but it was not by violent method, but non-violent method. All that simple. Why Steve Jobs is hailed as a hero? The internet was available, the phones were available. But what he did, he put a simple thing in the same platform, the internet and smartphone. Looking at society differently, that makes a lot that create a lot of impact. That's what Draupadi was speaking about. It is quite easy to follow what others doing. If you come to my hometown, it is known for handloom industry and as well as plywood industry. Somebody at first point of time started the plywood industries or in handloom industry. Everybody start following. They maybe might have made money, but who started first? Who is selected to be called as a successful? Why the Aaron BB has been considered as the most successful business entrepreneur. It does not own single real estate, but they are the largest service provider in real estate. Similarly, the Uber, Ola, the largest automotive. Who's doing it? Automotive services, Uber, but without owning a single car. They made a difference in this world and created a different impact on the world. People were using car before, but what difference it made by Uber? It put a different level of service to the people. It made all the differences. Car was there much before, taxis were operating. Similarly, when you come to the court, when you find a lot of litigations happening around. Same thing is being followed. The question is, can you make a difference in their approach? And it can be made more service-oriented, more friendly to the people. Today, we must remember the litigation was the days where when I started practicing, people never care about the delay involved because their egos always propel them to fight. There were a lot of people carrying the files on the shoulder. I mean, you might have found a lot of such clerks in those days. Of course, you might not seen now. But there are a lot of litigants. Never mind about it. They fight for even for half cents of land, which may be worth 5,000 rupees. But they will spend lakhs and lakhs of money for that. They fight with the neighbors. Today, people are looking at litigation as a service-oriented field. And there is, I must say, absolutely no service being provided by lawyers to satisfy the clients. Lawyers only concerned about their case and winning the case. As far as the client is concerned, it is not your written skill matters or a forensic skill in cross-examination matters. For him, it's a delivery. I am a practitioner in civil court for 7 years in the Kannur. I know. After judgment, I never care about what happens in the execution petition. It takes many, many months. Client is more concerned about execution delivery, which we always entrust with our clerks. We hardly care about that. Once you win the case, we will say that my job is over. We never treat it as a service sector to serve the people. Perhaps we need to think in a different way. This is where the real problem starts. I'll give you a brief history of the litigations in India and what is going in the future. If you look at the history of our country, you will know how the litigation practice evolved over the years. During British period, there are a lot of practitioners. They've been hailed as heroes. If you read a lot of old textbooks, all the journals, and all you find such lawyers. They were more expensive lawyers. Even Jinnah, I was told by one of my brother judge long before. The Jinnah charged around 10,000 rupees those days. 10,000 is a huge money. Like today's maybe equal to 50 lakhs or something like. The laws are very rich those days. But their practice was focused on civil or criminal. These are the two fields available to them. And after 1935, when the Federal Act came, somewhat we have some kind of law related to our polity, except related to the British. We started recognizing certain principles, the constitutional idealism. But when Constitution came, the scenario altogether changed. The lawyer's role became so prominent in those areas, whether social or political justice. The lawyers played a prominent role. They defined what is a liberty. They defined what is a social justice. It is because of the lawyers' ingenuity we have a vibrant constitution now. Otherwise, constitution would have been destroyed by parliament based on the majority rule. The parliament cannot touch upon the constitution, and so far as related sport principles, basic structure theory evolved in Kashmir and the Bay. Nowhere in the constitution you find basic structure ideal. It is a German ideal. It is imported to the constitution through the ingenuity of lawyer. So today, we have a constitution. We have a the democracy is still guiding to us. We have a secularist nation, all because of our constitution, and all that has been contributed by the lawyers. So see the shift. The lawyers who were practicing on civil, criminal, shifted a role defining the quality of this great nation. If the lawyers have not shouldered themselves the responsibility to define this nation, what would have been remained? Where would have remained? We still continue to be civil or criminal litigate lawyer. Is it not? So lawyers responded to the requirement of the society. They understood the constitution and its ideals and its principles and defined it. So you can see visible changes in the role of and responsibility of the lawyers. But really, lawyers face a crossroads and challenge during post-90s. That's where the real problem, as far as the lawyers can say. The old generation could not sense what is happening in this country. At least new generation know what is happening around. The liberalization policy of the government. I'm not critical of that policy. It's good. It is focusing on the market dominations, market idealism. And there, markets are open cross-border transactions. There is a flow of foreign investments. We made a host of laws based on international understanding and conventions, Chitrel or whichever the TRIPS agreement, whatever it may be. You find the Information Technology Act, you find Amendment to Arbitration Conciliation Act 1996. Host of legislation came into existence. What is the approach of the government? Government today is, looking in terms of its growth of GDP. What Adam Smith visioned in 1800 in his Wealth of Nations has become reality in the last century. So what is a visible change that has happened in our country? It will be interesting for you to know. There are the days where we used to apply for telephone connection, landline, and wait for years and years, 5 years, 10 years. A lot of litigations happened in the High Court seeking direction for getting a telephone connection. That was happened in the 96 and 97. What revolution was brought by liberalization? Unbundled the network and opened the sector for everyone. There is no monopoly of the telecommunications. What is the visible change you can find in the house country and everywhere in the world? Is the economic revolutions in a sense. But our constitution was made in 1950. Where it postulates and envisioned a socialist democratic culture. How do you balance those concepts? The market economy, where the spirit of market economy and non-state actors, large multinational company would define the future or the life of the citizens of the country. There is a law for us. How lawyers are champion for the cause. Last week, I read a newspaper. The Honorable Minister, I think, Commerce, I don't remember, he raised some concern about the WTO's policies and the agriculture reforms, because he said that it is suited for developed nations, and it will have a far-reaching consequences in underdeveloped countries. And the lawyers who champion the cause of the citizens of this country, post-constitution, determining social and political interests of this country, are not visible post-1990. Where have they gone? This is where really we need to think about. This is the first scenario. The second scenario, we are said to be in the fourth revolution, the revolution of the technology, agriculture, industrial, and cyber, and fourth is the technology revolution. The historian Yuval Harari, the Israel, he has written a couple of books you must all read. He said there will be a class, useless class. Not because of they don't know any vocation or they're not skilled in doing certain things, but by passage of time they become a useless class. For example, when driverless cars are on the roads and the algorithm, the network, artificial intelligence propel their driving, the drivers wrecking out of the livelihood, driving the taxis and all, you have to disappear. The smallest example he has given, he said they become a useless class. They're not fitted to do any job, because all the years they were doing a particular job, all of a sudden they have to disappear. So he coined it as a useless class. So there is a fear psychosis for us. Are we going to be, some of us, with a useless class in the near future? So these two scenarios, one is a challenge posed by economic revolutions, where we don't have an answers. Our system is not equipped to deal with economic justice. There are a host of issues in economic front. James Buchanan wrote a book called Constitutional Economics. I think Constitutional Economics is a Nobel laureate. You must read it. Of course, he tried to define economics in terms of constitutional idealism. How Constitution is a document to remain forever. We have to interpret our Constitution in tune with the times. The challenges we face with the time, we must find answers in the Constitution. Where are the lawyers? Are they equipped? So I told you now the herd mentality. You follow what others follow, then of course, absolutely, you can't create impact. That's what Revati was speaking about. You need to make an impact on the society. You can read the pulses and senses of the people. When you look around, you find that the economic revolution is happening. Absolutely nothing wrong with it. Absolutely nothing wrong. This is where country can have to progress. At the same time, are we in a position to ensure economic justice to the people of this country? Our constitution proclaims in preamble justice in all terms, economic and social and political. Are we equipped to explore any principles of economics and define in terms of constitution? You might have studied in 5 years LLB in economics in a very basic level. How you made it in a way to understand the constitution in present times. Whether it matters to you. Similarly, technological challenges. Artificial intelligence, of course, is essentially an interpretation of data, what is fed into the artificial intelligence, machine. The machine uses cognitive skills and interpret data. It can assist us in many ways. How far we'll be able to use this technology? Are we equipped ourselves learning technology and make an impact in the society? That's where you have to conquer. The making difference, that's what Revati was speaking about, is all that matters. That's what I said Gandhiji did to our nation. He made a difference. He could have led resistance movement to violence, but he stand out. He proposed an idea a different way. People could understand and realize. That's what Sri Narayana Guru did. Same thing, looking at a different way. The perspective and the approach make them successful. And how are you going to approach the future? You just follow what your predecessor said. Then, of course, you can make him rich, you can earn money, but that will not make any difference in the society. The successful lawyer is not the one who earns money or who having a lot of facts. Successful lawyer who shows others the path and brings the changes. You have to think differently. There are 3 career approach for you. That's what, according to me, one is there would be going to be a distinction in litigation practice focusing on public law and private law. That's the first category of the career you can have in the future. Secondly, as you know, the transaction lawyer or a corporate lawyer assisting corporates. That option is also. The third option, I would say, is there is going to be a great demand for the legal support, which I need to explain a little bit. I will explain that. The legal support. Perhaps that is not evolved so far. That's need to be evolved in our country to bring changes. So first, I'll just categorize the 3 parts for easy reference. The first part, I'll just make a few remarks. The first is I said that there will be going to be a complete compartmentalization of litigation practice, focusing on private and public. We know that there are ADR mechanisms, and the court itself has taken forward the steps by providing a mechanism for dispute resolution to using ADR mechanism. So what is significant aspect that has happened after 1996 Arbitration Conciliation Act? Like many other sectors, the litigation is no longer became a monopoly of the court. Like our BSNL, I think I don't remember its predecessor. Johnson might be a telecommunication company in India. Like that, the litigation also became a private. Less interference of the court in arbitration and complete autonomy is given for resolution of dispute without intervention of the court. That was a significant feature in 1996. Post 1996 onwards, there is a complete space, being earmarked for resolving the dispute in a private space without intervention. But unfortunately, we could not realize and tap the situations. Of course, people like Johnson Thomas are trying to now create a platform for resolution of the disputes through the question arbitration centers, etc. That is a great initiative. But our lawyers have not understood the opportunity available to them and resolve such private disputes in ADR mechanism. I think there will be a great shift in practice in the future. All that private dispute will be resolved through the ADR mechanism. And courts will be focusing on larger public interest, like nation's interest, state interest, criminal justice, etc. So court will be less burdened with a private dispute and more focus will be the public law remedies, etc. There will be complete shift of private practice to the dispute resolution from court to the private dispute resolution mechanism. I think you can contribute a lot instead of thinking that you create a space. Instead of thinking that such practice will evolve, you try to create yourself an imprint of utilizing this opportunity and provide a mechanism, credible mechanism, for resolving such disputes in the ADR mechanism. I think you might be knowing what are the ADR mechanism. You might have learned mediation, arbitration, conciliation, etc. So enough opportunity has been provided under law for such private. This is compartmentalization happens in the first category. The second category, as I said, which I need not to mention about much about it, transactional lawyer, corporate lawyer, etc. You all know what is happening. The third is very important, which I need to deliberate with you and share with my thoughts on that. The legal support system, today is a world as strong as a village. Our borders are open up cross-border transactions. The technologies are limited. We need to use this technology to define new legal instruments. You might have heard of cryptocurrency, right? Many of you know the cryptocurrency. Cryptocurrency is it's called a ledger technology. Ledger technology in the sense, whoever the network alone will be able to get the data. For example, I'm in the network, and Renju and Johnson, Sandeep, or Revati in the network, we alone be able to transact. So its authenticity is assured otherwise. Any corruption and tampering or tinkering will reflect upon the network of others. So accuracy is 100%. Unfortunately, in this country, we have not made law. People made technology, but we don't have law. Lawyers have not understood what is a technology. So cryptocurrency, of course, I think there are a lot of issues surmounted it. RBI, I don't know whether it's been clearance or not, but it's a fact. There is innumerable opportunity using such ledger technology or such technology for advancement of economic interest of the parties, the litigants. The technologists need to know law. Same way, lawyers also need to know the technology. We need to have interdisciplinary subjects in the law colleges. Many cases are coming up before in the court under the Foreign Marriage Act. Suppose a foreigner wants to marry an Indian, and under law we're supposed to have a marriage officer in an Indian embassy in a foreign country, but we don't have. So many litigation comes to us saying that I'm marrying a foreigner, for example, a Russian. This is often a lot of litigations in high court. Then court will ask, because marriage officer is not there in the embassy in a foreign country, so we'll ask them to produce a single status certificate. And somehow they will produce a single status certificate. So then we say that, okay, ask the marriage registrar in Kerala to register the same. This is a routine mandamus we give in high court. But think about having a simple marriage register for the entire world using ledger technology. That's simple. If you are making a marriage register for the world, nobody else, only the entity in the world are linked. You would be able to open it and find out whether you are single or married. As simple as that. But you need to know the law. At the same time, you need to have a technology. Why can't you develop something like? So, the marriage register here opens your number for the identity of foreign country for the preference passport. Will get to know whether you are married. There are two private international agencies in the world. One is Hague Conference based in Hague, Netherlands. Other is a UNIDROIT based in Rome. They are working on different instruments. You can suggest to them, make something. They will accept it. It's intergovernmental bodies. All the governments would accept it in turn. They made a couple of instruments, like, for example, the notarization. They called, I forgot its name. They made a notarization, and if that particular notary is steel, that will be recognized in all the world. So similarly, if that international bodies can ask all the governments to accept its register, that is simple. The convention is accepted. Your document will be accepted worldwide. Think about something like that. Or simply think about international power of attorney. If it is executed in America or UAE, Australia, if you verify on the register this has been executed, all the countries in the world accept it. What would happen? Simple. I may not produce anything. I just look at in the online and find out whether from particular register there is a power of attorney or not. As simple as that. The world has shrunk as a village. The constraints of physical space is vanished. The constraints of time vanished. A simple technology can make revolutions, but you need to know little about private international as well as the technology. These are two simple examples I gave you. There are so many opportunities, whether it be in business. For example, business, I think exports require a lot of documents. And this exporters, the consignor from here to send all these documents across to the consignee, and customs, all this has to look at these documents. Johnson might be knowing a couple of documents. Why should, if I put in a document here in my system, the customs in other part of the world can also verify it As simple as that. There's so much of opportunities available for. That's what I said. Legal support, a kind of support, even can be given to the state, public institutions, government bodies, agents, etc. So there are, the opportunity is more in this world for lawyers to create an impact. I borrow the expression of the day that to create an impact. You can bring changes, but you need to know what is the pulse of the society. What is the society's requirement? Your response is to respond to such requirement. The creative lawyer, the person who's going to make it can be called a successful lawyer, is a lawyer who responds to the requirement of society, who brings the change to the society. Not that one follows others, not that one has so much of money or funds, not that one who has less file or more money. That's the herd mentality. If you follow the footsteps of others who are already laid, of course, you may have the money. You can build a house, you can build cars and all. But that is not a success. Success is created and earned. Thinking differently. Think differently. Think out of box. It is simple. It's quite easy to follow the footsteps of others who have already laid down their footsteps in the profession. It's quite easy to become a litigant lawyer or a practicing lawyer, judge, or magistrate, etc. But making a difference is altogether a different approach. You have to think. You need to think today in terms of the future. That's what the real problem for you. We created a space for us thinking in terms of past. We followed the footsteps of our predecessors. So our future was at that time when I was in parole order in a fashion formulated in the past by my predecessors. But for you, you can't look at us and define, but you have to look at it in a different way. You have to look in terms of future and define yourself. That is a great challenge for you. So I thank you one and all for hearing me. Of course, we can have a more deliberation on this. Due to time constraints, of course, we have 10 minutes more. You can ask any questions.
Yes, everyone. Thank you, sir. In between, I just want to inform you just that you are breaking in between, but I believe most of them can be made out. You were audible throughout the way, but in between there was some small breakup. That is the problem with that latest technology that we are using.
I think we should have used the Zoom. One of the problems with all the platform is that in low bandwidth, it can't escalate or bandwidth otherwise. Only Zoom is having that technology.
Okay.
That is why everyone is preferring Zoom. Even Google is not able to tap the technology.
Okay. So we will try to incorporate
Zoom. If connectivity is feeble, then it cannot augment.
Yes.
But Zoom can.
Yes, definitely. Now, I welcome the students and the other participants for asking the questions. This is a Q&A session. So we are open for questions. You can ask. Yeah.
Sir?
Can you please name yourself?
Yes, Nandip. Yes, I will. Yeah. Sir, myself, Rose Mariam Stibi. I'm practicing at Changanashiri Court. So, sir, I have a question, it's a humble question. Changes invites a lot of challenges. As you have mentioned, we should be ready for changes, but it invites a lot of challenges. So, do you have any advice for being ready to face the challenges?
Yeah.
Getting ready.
You have to mentally prepare. And any lawyer would be different when you enter into the bar, and especially litigant lawyer. Many time I thought should because it's very difficult for me to being a lawyer in the environment of lawyers. As I said, it's not a good environment. The surroundings are not good. They will never recognize you. They will never encourage you. Everybody boosts themselves, and unethical practice is prevalent. This is a big challenge for you, especially young people like you. You are very open-minded people. A new generation have a different. So it is quite easy. It's not easy to sustain in such environment. Only thing is that be positive, be optimistic. I always believe in Vincent Van Gogh's approach. If you like your passion about it, do it with passion, and never think about what you get out of it. And there will be day one would recognize. If you read Vincent Van Gogh's life story, you know his painting he took to Paris Gallery. In Paris, if you go there, I've seen most of the museums. There are a lot of painting displayed. Even street paint, you can find street painters there in the streets. And he took his paintings to the Paris, and they never recognized his painting. They, just brushed aside, but he never lost. He continued to do painting. Even he's chopped up his ears for his lover. But after death, people are recognized, and he hailed as one of the world best, a great painter. So if you follow passionately whatever you want to do, nobody can stop you. But at the same time, you have to think in the futurist. I'll give an example. You might have seen in a bridge in Honduras. You might have come. You just search the bridge in Honduras. I have a painting. If you come to my chamber, I'll show you one. It is still hanging there. In Honduras, a bridge was built initially over the river. Then after long, the river diverted and start flowing in a different dimension. The bridge became useless. So if you come to my chamber, I'll show that one day. If you want to intern with me, you can come. Of course, you can ask my PS. You can come any day. You can come. No problem.
Thank you, sir. Thank you.
So you have to be very futuristic as well when you face the challenge. You have to think in terms of future. That's what I said. We depend on future in terms of the past, but you can't define your future in terms of past, but you have to define in terms of future itself. Yes, Rahul.
So this question is regarding arbitration. Initially, when I started reading about arbitration, one of the things I read about is challenges to arbitration. So one point was that courts' interference can be a hindrance to arbitration. I just want to know your opinion on it, sir.
Interference is very minimal in the sense there are enumerated grounds under Section 34. So that only is available for a grounds of challenge. But still, the problem is not a grounds of challenge, but the time consumed in the court in responding to such challenge. That's, in fact, I put an answer on the people accepting arbitration as a medium of resolution. And you know that a lot of advocacy prevalent in arbitration. There's lack of standard. So people like Johnson and all is trying to bring uniformity in standards. Such standards certainly will enhance the quality of the arbitration. Advocacy prevalent and it's open source some corruption. And now I'm making a lot of attempts for the government to pursue arbitration. Somewhat nearing for a possible response to the government. Government, state of Kerala entered a lot of arbitration earlier, but a lot of corruptions, the arbitrator as well as the officials colluded. And government also brought in a legislation saying that scrapping all agreement. That went into trouble. That is still pending Supreme Court. Now I'm trying to pursue the government for ease of business to bring the disputes which are raising out of the government contract under arbitration. So you are right. The intervention of the court may and the delay involved in the court hampering its acceptance. It's an easy mode of resolution of disputes. It's arbitration challenge can be only on minimal ground, which is referred in Section 34 of Arbitration Conciliation Act. And you can't challenge domestic foreign arbitration except resisting against enforcement. We can have a session on the arbitration after Johnson may be doing it in the future. Yes.
Yes, sir. Everyone, kindly raise your hands. If you want to ask questions, first raise your hand. The option is there. And try to. Revati, yeah.
Where are you studying?
So I'm studying in Government Law College, Thrissur, sir.
Okay. Okay.
My question is that, as you said, private dispute resolution and private institutions will come up in the future. Will that not create problems? Like there will be less secrecy, more secrecy, less public. So will not it create some problems?
I think the transparency in the private arbitration is something is, of course, credibility. I would say that that's what the real problem for the. As I said, the institutional arbitration will have more accountability, and if it brings a certain amount of standards for arbitration. There are players, as you pointed out, in regard to less transparency, more prone to corruptions in ad hoc arbitration. But institutional arbitration is less. There are more standards, and of course, now we have a schedule in the Arbitration Conciliation Act for the maximum period of conclusion of the proceedings. But you need not worry about less transparency in the sense this is even arbitration. It's an open system. It's not done in a camera. Both parties are given opportunity of hearing in. So in that way, of course, it is not. But there is a fear of credibility. That credibility being answered by through institutional arbitration.
Yes, sir. Thank you.
I believe Aravind has posted a question, and Abhiram also subsequently raised his hand. But I will read the question raised by Aravind Prakash. Sir, how to make a career in international arbitration and dispute settlement? It's a very direct question he's trying to ask.
I think, the international arbitration is basically arbitration. The only thing is that the entity who are parties may be in international transactions. India is not a hub for international arbitration. Singapore, Hong Kong, London have been considered the hub for international arbitration. So if you want to create a space for you in international arbitration, one is that best way of it getting yourself an exposure to such field. For example, there are some organizations, even the International Commercial Chamber of Commerce in Paris, they have also mentoring young arbitrators. You have to join their programs, getting to know people, get into that. Even extending help to the business people here in India. When they're entering into international contracts, you should know about you should also the structuring such business, and moreover, you need to know the private international. So when you're private international is not on the elementary level and higher level, even to know the private international law is actually not an international law. It's a domestic approach, an issue of transaction of having a foreign element. So you need to know about laws that is being followed of different countries in such issues when there is a foreign element. So that will all make up. Then over and above a network. Networking means not soliciting. You are attending a lot of international programs, the lecture series. You get to know about a lot of people. So that itself build your network.
Yes, I hope that answers the question. I now move on to Abhiram. Abhiram has raised his hand. Abhiram?
Sir, am I audible?
Yes.
Sir, after every enrollment, we can see that a lot of laws are crowded in the court premises. So aftermath, if you observe, it will decreasing in day by day. So in the case of women, it is too less, sir. So my question is, why the ratio of women lawyers in comparatively less than compared to the male lawyers, sir? Sir, can you please share?
Sorry. Can you mute?
Sir, hello?
If you come to High Court, please mute yourself so that there is no please mute. There is a technical issue. Abhiram, if you come to High Court, you find that there are more women lawyers than men, especially young. I think one of the problem is the mindset of our society. They are not prepared to accept the women as the lawyers. If you ask me to rate who are the good lawyers, I would rate as far as young concerned. The lady lawyers are better than their counterparts. Absolutely, I know. I'm seeing day-to-day basis in the High Court. They outperform their counterparts. But unfortunately, the patriarchal mindset of the society, they hardly accept women lawyers. And society's compulsions, family compulsion, others. And some of them might be sacrificing now. They want to come up in the profession. But in a way, they are not lesser. But they are more smarter than us. They have a very open approach. They have more empathy, sympathy, etc. And the judiciary find the recruitment, the substantial, that 2/3 at least recruitees are the women. So they get space in other ways. Even if the footfall in the courts may be less, but their presence is more in the judiciary or in High Court. Maybe in future, in near future, there will be a lot of more access into the women laws.
Okay. Thank you for the response, sir. Due to the paucity of time, we can only have one more last question. Anyone? The last question? Who wants to ask the last question?
Am I audible?
Okay. Yes, Alexi Joy. Yes.
Yes, sir. So I have a query that what about the role of artificial intelligence, or about artificial intelligence in law, or whether the artificial intelligence in artificial intelligence solutions, whether the structure of economics or the legal profession, which will make the training for legal profession for future generation?
Yes, I would answer yes. But there are many ways of future will be more concerned. The chunk of work will be taken by artificial. For example, I'll cite some examples. For one of the US firm, a robotic lawyer is practicing bankruptcy. So if you have a subscribed service, you can have a subscribed service. The robotic lawyer will give you immediate response in reply. Instead of searching a large number of files and books, the robotic lawyer will have an immediate response. So giving legal opinions, vetting documents, that is likely to be taken over by artificial. Similarly, where the interpretation of data only matters in such cases, artificial. For example, motor accident claims. A substantial number of cases in motor accident claims are based on data. There are structured formulas, there are structured principles. The machine can predict the compensation payable, or even can decide on the liability. So that will be a machine-assisted justice will be soon come to our courts. But there are areas where artificial intelligence cannot be deployed. For example, justice. What is a justice? How you determine justice? Where artificial intelligence cannot. Justice is something in a kind of an ethos. It comes as a virtue. The artificial intelligence is basically what interpretation of data using cognitive skills. The interpretation, the data is already fed, so it has its own limitations. Justice being identified is more of, we make it as a transformative. Then it requires a lot of human element. It evolves around your compassion, empathy, many other principles. The virtue you understand, vices you want to eliminate, etc. will play an important role. In that, human alone can. That cannot be supplanted through the machines. So yes, artificial intelligence will play a prominent role, pivotal role in administration of justice. Similarly, it will have a lot of play in defining contractual terms, many other fields. It will have an impact. It will have an impact. Legal opinion, and you just ask the machine will do. There are machines which can even lay down propositional laws, even personal laws. So it will have a lot of impact.
Okay, sir. So unfortunately, yeah. Thank you for the response, sir. Unfortunately, due to the paucity of time, we have to end the session here, the Q&A session here. Now, in order to deliver the vote of thanks, I would like to welcome one of the students of Project Complete Lawyer, one of the student coordinators, that is Rahul Arnath. I welcome Rahul Arnath to this session. Rahul?
Honorable Justice A. Mohammad Mustaq, Advocate Johnson Gomez, and Convener Mr. Sandeep, and all the participants present today. I take this opportunity to propose to vote of thanks. Today's career orientation HSCB's topic was about future of legal profession, prospects, and challenges. Honorable Justice A. Mohammad Mustaq sir has extensively talked to us about the future of legal profession. He started out the session by asking us what would constitute or what would require a lawyer to be successful, or who is a successful lawyer. So he's shed light on us by telling us that it is important to stay away from herd mentality and to look at law with its growth. He's also talked about how there are three kinds of fields that a lawyer could take. First would be there would be a distinction between public and private law. Then he talked about transactional lawyers, and then he talked about legal support systems, the importance of legal support systems. So he's talked about how the growth or the liberalization and the globalization has created a gap which needs to be filled. It was a very engaging and thought-provoking session, sir. Without delay, on behalf of Cochin Institute of International Arbitration and Law and Justice Research Foundation and all the participants present today, I would like to thank Honorable Justice A. Mohammad Mustaq for sharing his valuable time and for joining us here today. Thank you, sir. I would also like to take this opportunity to express my gratitude and appreciation to Cochin Institute of International Arbitration and Law and Justice Research Foundation and to all the participants here today for organizing such a fruitful online session. Thank you.
Thank you, sir. Thank you so much.
Thank you, sir. Thank you, sir. Thank you.
Thank you.
Thank you, everyone, for joining today, and we will see you in the next session. Okay, everyone.